हेलो दोस्तों, वेटरन्स नमस्कार। मैं दीवान सिंह। मैं आपको बताना चाहूँगा, हमारे कुछ एक्टिविस्ट लगातार अपने विचार सामने रख रहे हैं और कुछ सॉल्यूशंस भी दे रहे हैं और गुस्से में भी हैं। ऐसे नहीं है। जे शुक्ला साहब ने एक लेख लिखा, बहुत गुस्से में लिखा है। मैंने एक बार सोचा पढ़ूँ या नहीं पढ़ूँ, लेकिन मैं सोचा पढ़ना बहुत ज़रूरी है। और मैं जिस बैकग्राउंड में बैठ करके वीडियो बना रहा हूँ, मैं भगवान से यही प्रार्थना कर रहा हूँ कि हमारे ज़िंदगी में प्रकाश आए, और सामने से प्रकाश आ भी रहा है। एक जो डिवाइन जैसी वो है, पूरा का पूरा वीडियो ऊपर वाले की ब्लेसिंग लेते हुए हम बना रहे हैं। अब मैं ज़्यादा नहीं बोलूँगा, शुक्ला साहब का लेख पढ़ूंगा, काफ़ी लंबा है, टाइम भी लग सकता है। कहते हैं, ना मुझे स्वर्ग की इच्छा है, न तुम्हारी, न राज्य की। बस इतना कर सकूं, मैं गरीबों की या दुख पाने वाले लोगों की सहायता कर सकूं। इसी शुरू करते हैं और वो एकदम बहुत नाराज़ी में लिखते हैं, हे ब्रो, इट इज़ नॉट गॉसिप अड्डा। ये गॉसिप अड्डा नहीं है। इट इज़ ऑनरेबल सुप्रीम कोर्ट, बेंच नंबर 2। दोस्तों, टोन को समझ सकते हो। बी प्रिसाइज एंड स्ट्रिक्टली टू इश्यू। डोंट स्प्रेड रायता। रायता मत फैलाओ। कुछ बातें ऐसी हुई थी, उनके बारे में ये कह रहे हैं। देयर इज सेइंग, अ बर्न्ड चाइल्ड ड्रेस द फायर। दूध का जला छाछ को फूक फूक कर पीता है। जो डी न्यूट्रलाइजेशन में जो हुआ था, EIBRF की वजह से जो केस हारे थे, आशंकाएं अभी भी घर कर रही हैं। कहते हैं, pensioners 100% DA case was lost in the Supreme Court due to the alleged treachery of infamous General Secretary of EIBRF। जैन साहब की बात कर रहे हैं। People suffered losses for 21 years. None supported due to strenuous efforts of the forum. The BMS came to rescue, helped to resolve 100% DA। क्लियर हो गया। BMS ने 100% DA को 2023 अगस्त 2023 से सुलझवाया था। We fear that something like this may not happen in the case of pension updation. No one's mistake in the single case should lead to defeat in the Supreme Court. Apart from main appellants, there are some impleaders. In this case, one of them is a unit of AIB Park. The entire responsibility of the case rests with the appellants, but the court also listens to the impleaders. There is no need for the court to pay heed to their arguments. Nevertheless, the need to exercise caution and vigilance cannot be ignored. Next, can anyone imagine that a big leader of AIB Park can cover up the big nonsense of his lawyer by saying slip of the tongue in the Supreme Court? He stated, lawyer have convinced the judges the decision will be in our favor, and after Singla's death, his supporters did nothing. We are these nonsense. Hearing this, any informed person would consider it boastful or a drunken blabbering. Their lawyer kept wondering, and he says that the judges have understood the matter. As far as explaining the case is concerned, no one has explained it yet. And even if someone did explain, he is anonymous. The verdict will be in favor or Sangla supporters did nothing. Such nonsense is nothing more than सेल्फ ग्लोरिफिकेशन। कुछ लोगों ने कहा कि सिंगला के केस वाले कुछ नहीं कर रहे, हम कर रहे हैं। बोला, ये बेवकूफ़ी भरा बयान नहीं दें, ये रायता नहीं फैलाएं। आगे, टुडे द कोर्ट रूम इज ऑन द वेब। Anyone from anywhere can see what is the plaintiff, defendant, honorable judges are saying and doing in the court. Whatever was done by the impleaders lawyer on 5/2/2026 and 25/2026, the question has arisen whether they are on behalf of the pensioners or the B team of the main respondents, banks and IBA। उनके शुक्ला साहब ने उनके कार्यकलाप को देखते हुए कुछ शंकाएं व्यक्त कर दी हैं। The bench of Honorable Supreme Court is not gossip atta, where slips of the tongue go unconfessed. This is the Supreme Court of the country, where there is no scope for taking a slip of the tongue as gossip. The mistake made here cannot be rectified and cannot be reversed. The party itself has to bear the brunt of the slip of the tongue in the court. We have sometimes written in our previous articles that generally every lawyer knows that he has to say in the court, but very few know what is not to say. Here everything turned upside down. Whatever was to be said was not said, and what was not to be said was said on both the sides, both the days. In court, slip of tongue are taken as revelations and admissions of facts that one is trying to support. The system of cross-examination in the court is with this intention, so that through it the suppressed fact can be brought out. 5 out. 5/2/2026, the way pension fund was analyzed was not a matter for the impeders lawyers. It was like to invite trouble. Even if the main respondents raised the issue of the fund, it would be absolutely illogical to dismiss them as irrelevant because the pension payment or pension updation is not based on the financial position of the pension fund. Fund can never be an issue because pension fund has itself a guarantee to get an amount to. शुक्ला साहब ने जो जो बात कही है, एक एक बात इतनी वजनदार है, इतनी वजनदार बात है, ये उनके कानों में जानी चाहिए जो जो ये गलतियां करके बैठे हुए हैं. कोई भी स्पेयरिंग नहीं है. किसी प्रकार की गलती उनकी इमेज को, उनकी पॉपुलरिटी को धूल धूसित कर सकती है. पेंशन पेमेंट्स एंड पेंशन अपडेशन along with pay revision is a regularly provision of the pension agreement in pension regulation. As per the rules book, pension updation is a right which is the respondents are not doing arbitrarily. The issue is regarding pension updation on RBI lines as mentioned in the pension settlement. Small committee decisions BPR 995 updation under clause 35(1) and admitted status of periodic pension updation along with wage revision, which was implemented at the time of the implementation of pension but not with the subsequent wage revision settlement. Despite pension updation RBI, the bank party to be the pension settlement 29/10 did not do updation. The lawyer who was not so prepared was standing there not for pay updation but for pension updation. The issue to be considered is basic pension, not basic pay. It is not even a question of annual increment. Annual increments are for working employees. There is no element of annual increment in pension case. The demand of pensioner is not for periodic pension updation along with wage revision, and the wage revision is done once in 5 years. Obviously, the pensioners are demanding pension updation along with the wage revision to be done once in five years. Was the deviation from the real issue a slip of the tongue or something else? आगे कहते हैं it has become clear from the information of 3 periods sought by the Honorable Court that the basic pension fixed at the time of the retirement remains the same. There has been no updation of basic pension. The respondents have not even denied this reality. There is a provision for updation. It is an admitted position. Pension updation along with wage revision is an admitted position. It has been implemented too. Once pension updation was done for the pensioner between 1/1/1986 से लेके 31/10/1987, thereafter no one got any updation from 6th to 12th by-part settlement. In this way, the basic pension drawn at the time of the retirement from 1/1/1986 till date has remained the same. Dearness allowance decreases on the basic pension. Singla is about updating of basic pension along with wage revision. As far as ex gratia amount is concerned, from 1/11/2022, taking cognizance of financial plight of the pensioners, the government was pleased to give one-time relief to the pensioners of public sector banks. That the ex gratia amount has no connection with the demand for pension updation, and there is no provision for ex gratia amount in the pension settlement regulation. This was neither a demand of pensioners nor it is a substitute pension updation. We hope that no one will create any more mess in the next hearing on 12/3/2025. अब वो सलाह दे रहे हैं. The main respondents will definitely indulge in widow's lament, vidwa vilap on fund, which has nothing to do with the right to pension updation of pensioners. This is the bank's own problem. At present, public sector banks are earning profit of around 2 lakh crore annually. Also, by not updating the pension periodically, the banks have pocketed billions of rupees from the pensioner in last 7 wage revision agreements made in the last 35 years. During this period, about 2.5 lakh pensioners died who did not get the right of updation, and 7,80,000 current pensioners are living in the financial poverty for want of pension updation. This is a great human tragedy. May call it organized genocide by PSBs, IB or government. The respondents are directly responsible for that. All this is happening in banks owned by the government of India. This is most shaming aspect. JN शुक्ला नेशनल कन्वीनर, और उनका नंबर भी यहाँ पर दे रखा है, नंबर आपको पता है। दोस्तों, जिस प्रकार से शुक्ला जी ने अपना गुस्सा जाहिर किया है और सच्चाई सामने रखी है, आप देख सकते हो। बहुत लंबा लेख है, मैंने जल्दी जल्दी पढ़ा है, लेकिन आपके समझ में आएगा। शायद जितने भी ये लोग हैं पिटीशनर, पिटीशनर के वकील, और खास करके AIB पार्क और ये अराइज वाले ज़्यादा उछल कूद करते हैं, उनकी अच्छी खासी क्लास लगा रखी है उन्होंने, इंटरवीनर्स की और इम्पीडियर्स की भी। कोई मजाक नहीं हो रहा है ये 7,80,000 लोगों की जिंदगियां फंसी हुई हैं इसमें, और वह स्लिप ऑफ टंग चले हुए हैं। वो स्लिप ऑफ टंग नहीं चलने चाहिए। और बड़ा स्पष्ट बोल दिया शुक्ला जी ने कि हर हालत में पेंशन अपडेशन का जो फंड है उसकी चर्चा नहीं करनी है, वो हमारा काम नहीं है। अब मैं यहीं खत्म करूंगा। थैंक यू, धन्यवाद।